everybody. It's Ed Rosenberg again, and this afternoon I am speaking to Yael Cabilly from Tel Aviv, Israel. Yael, how are you today?
I'm good, thank you. Thank you for having me.
I know you're based in Tel Aviv. You're a New York attorney. How did you get involved with Amazon sellers, please?
I'm a trademark lawyer. I've been dealing with IP issues for over 13 years. And a few years ago, one of the Amazon sellers came to me, and I remember he had a problem with a trademark. Some company was claiming that he was infringing a trademark. So I helped him get out of it. I spoke with the lawyer, and he didn't have to change the trademark. He was very happy about it. And then he asked me if he could post, if he could post on Facebook his story. And the next day, about 20 other sellers came to me and, asked questions about IP. One of them wanted trademark, and another one had a suspension related to IP. It's a word-to-mouth world. So today I have a firm of 4 lawyers and 2 paralegals, and that's what we do. We do Amazon. 90% of my business now is Amazon.
Is the other 10% like Walmart or Jet or outside the internet?
Both. Mostly outside of the internet, infringement of other brands, not necessarily related to Amazon or online sales.
Okay, so now we were discussing this in the group a couple of days ago, and I gave what I thought to be the correct answer. And the basic question is this: if I have an Amazon listing which is trademarked, but there's nothing unique about it, there's just a sticker of my name on the item, and another seller does exactly the same thing, doesn't use that sticker, uses his own sticker, and he lists it against it. Based on my experience, Amazon will often not remove that. Has that been your experience? And is that
honestly no? Maybe when a lawyer files a complaint, maybe the situation is different. But no, we've been able to remove those. And I'll tell you more than that. I think that legally, I think this is trademark infringement. And I told you, I don't think there's a difference between a large brand and a private label. If you sell on your listing, you have a trademark, your brand is protected. Now, if I come in and I start selling on your listing, I'm actually using your trademark because your trademark appears on the listing, it appears on the photos, on the description, everywhere. So I'm actually using your trademark, right? I'm using it.
No. I'm not saying big or small. I agree that a small company is allowed to package and have their own item. I'm not talking about such a case. I'm talking about a case. Let's say I take 2 water bottles.
Yeah.
And I put them together and I put my sticker on it.
Yeah.
And then someone else comes and he ships the same 2 water bottles and he puts his sticker on it. Yeah, without the sticker. But there's nothing representing the sticker. There is no description. There is no website. There's no manual.
But the guy is selling on your listing, right, Ed? He's selling on your listing.
Yeah,
right?
He's selling on my listing. He's selling on my listing, but there's nothing unique on the listing, which makes it my listing outside.
So you're saying that it's not unique, but what I'm telling and what I think legally, when you have your trademark on your listing, okay, let's say you trademarked it Ed, okay, and you went and you registered the trademark Ed in relation to bottles, right? You have a registration. The word Ed appears on the title, it appears as the brand, it appears on the photos, right? It's part of your branding, of your product. Now, the guy that sells on your listing, he's there. And when people buy from him, they think they buy Ed. So he's misleading consumers to believe that he's selling the Ed product, the brand, okay, that you registered, and he's actually using your trademark because the trademark is there. Whether he wants it or not, the trademark is there on the listing. So he's using the trademark and he's misleading consumers. For me, this is trademark infringement. I mean, this is what the law says. So your sale, there's nothing special about it. That's not true. You have a trademark. that you don't need to be what I was saying when I was saying large brand. You don't need to be a large brand to have a trademark and to have value in that trademark. You only need a registration. If I have a trademark and you started, a separate website and you invested millions in that website and you became, super important and popular and everybody knows your brand, I still have the trademark. I was there first. I can stop you. You would be infringing my trademark. So the same reasoning here. If you use, if you go on that listing and there's a trademark in my name and you use it and you're not selling my products, this is infringement.
Right. So you don't think that that link, what was going around about it needing to be distinct in the marketplace, you don't think so?
So the distinctive part, your trademark needs to be distinctive, but Ed is a distinctive trademark. As an example, what's not a distinctive trademark is, for example, if you call your brand Great Bottles, okay, this is not a distinctive trademark, okay? So you would have, it would be more difficult to stop me if your trademark was Great Bottles. But if you have a distinct trademark in the sense that it's not something descriptive or generic, it's a real brand, then that's a trademark, and that's a trademark you should be able to enforce. So if you have a registered trademark, we can get that hijacker off your listing.
Okay, so you're saying that in order to protect the brand, you don't actually need your own packaging, you don't actually need your own manual. You don't need anything.
Well, it helps because you would have, first of all, before you have your trademark, when you're in the process, you want all those things, it really helps you removing the guy. Because when you don't have a trademark, you need to show Amazon that the product is different, right? To have the test buy and to show them the differences. So if you don't have those, then, they're going to write on this listing for months until you have your trademark. But once you have it, I believe it's not that important. And, we were talking about, larger brands. If I came on Nike's listing, right, and I started selling an identical shoe that I bought in China without the brand Nike on it, right? And I go on Nike's listing. That's the same thing you're saying.
Not at all, because I'm not wearing a Nike.
Not now, but you usually are.
Yeah, I usually am. And people like Nike. So in Nike's sense, it's people, they invested a lot of money behind that swoosh. So for you to ride their coattails, that's not fair. But to make a trademark and just call it by your name, Ed's, and
well, you can call it woo-woo or whatever, but the minute you registered your trademark, there's no difference between you and Nike. I mean, there are some legal differences in terms of how strong it is and everything, but it's not, in your case, it's the same thing. This is infringement and this is infringement. It's the same thing. That's what I'm saying.
So you think once you have a trademark, you essentially gated your brand?
No, because people will still be able to, to be on your listing, but then you can kick them out within, 24 hours or less.
Okay.
So gated means, nobody can go in, but you should be able to remove them.
Okay, so that's good. How fast can a seller obtain a trademark? And another question, is there any value in having a trademark that's pending?
So I got to tell you honestly, the pending trademark was helpful until I think 2 months ago or a month ago. It stopped being helpful. We used to file complaints with a pending trademark, and we were able to remove the hijacker even with a pending trademark. Now it's much more difficult. I need the test buy, and sometimes it helps if your trademark has been there for a while and you've been selling for many years. You can say that, and you may be able to remove it with a pending trademark, but it's really difficult. You can't compare it to a registered trademark. And how fast? I think the fastest I've seen is 4 months in the United States. you can also, we've discussed it, you can also get the brand registry if you have a trademark in other countries. For example, in the UK or a European trademark. I had sellers who could not register the trademark in the US because it was taken, or there was another problem, and so we registered the trademark in Europe, and they got the brand registry. But you and I know the brand registry isn't, doesn't take you very far. It doesn't remove hijackers. So if you have a European trademark and you have a hijacker on your listing on Amazon.com, it won't really help you. So you need a trademark in the country where you're active.
Mm-hmm. Okay, but for brand registry, it does help you.
So a brand registry protects your listing. So it protects your listing in the sense that if I come on your listing, I will not be able to change your photos. I won't be able to change your text, the description, the bullets, and everything. But the fact that I have brand registry by itself doesn't help you remove hijackers if you don't have a trademark. If you do have a trademark and you have the new brand registry, then the brand registry helps you.
Okay, how would I know in advance if a product has a patent or if a picture is copyright? Yeah, here we go.
Yeah, that's a hard question. So I wish there was a way. We get that question all the time. I wish there was a website I could tell you, okay, just type your listing and it will tell you if there's a patent or there's a design patent on it or copyright or whatever. There's no such thing. And I can go on and talk about it for 45 minutes. We can do a webinar about that if you want some other time. But I will give you some pointers that will help you avoiding infringement, at least in two cases, trademarks and copyrights. We see four kinds of infringement, okay? We see trademark infringement, we see copyright infringement, design patent, and patents. These are the four you see on Amazon. These are the most common. There's also trade dress, but it's really not common. So I can tell you how to avoid trademark and copyrights. Patents and design patents are really difficult to avoid. And I'll explain why. Trademark, it's a brand, okay? It's a brand, a word, okay? So when you have your listing, if you're a private label and you start a new listing, you need to make sure that the brand that you chose is not infringing someone else's trademark. So you go on the USPTO, you do a quick search, you try to search not only the same name, but also close name. It could also be infringing. And you make sure you're not using somebody else's trademark. Same goes for search terms. Sometimes some of my clients, they use a term like great bottles, okay? And they tell me this is completely generic, so there's no problem about it. And turns out it's a trademark. So when you see a great search term that your competitor uses a lot, make sure it's not a trademark, and search it on the USPTO. I can give you the links later. So if you have so if you're using a great bottle, okay, and there's a search term that your competitor uses a lot, then make sure it's not registered as a trademark, okay? Just make sure you're not using somebody else's trademark. This is quite easy. For copyrights, it's also quite easy. And, it sounds really stupid, but my advice is don't use somebody else's photos. Never, ever. Even if your suppliers told you this is my photo, you can use it, absolutely no problem. Turns out it belongs to your competitor, okay? So never use photos you received from your supplier. Make your own photos, take your photographer, and then you won't have problems with copyright.
Yeah,
at least for photos.
Let me ask you a question on that.
Yes.
But if I list against an existing ASIN,
that's not infringement.
That's good.
That's not infringement. That's not copyright infringement. So don't form a new listing and don't open a new listing with somebody else's photo. And the reason is that that guy has copyrights for these photos, even if he didn't register the copyright. People always ask me, how do I know if the photos are registered? There's no need to register copyrights, although it's possible to do it, and it's great, and it provides Amazon with a great evidence that it's his, but you don't need to do that because the law says that when he took that photo, he has copyrights in those photos.
Oh,
so he just has to show that.
Right, I'm sorry to interrupt you, but it's on that. How would I take somebody else off if I took the pictures first?
So I'll tell you how you do it. You file a copyright complaint, and in this complaint, you show them that this photo was on your website. You put your website, you show them that it was there. They can go back and see that it was on your website. There are tools to check that this photo was on your website a year back or, whenever. And you prove that you had the picture before that guy. And that's it. That's all you need. We remove those very easily. So this is a mistake that you just need to avoid, and it's quite easy to avoid. Just don't take photos from somebody else. And the same goes for text and for, graphic designs. The same. If I designed like a poster or a T-shirt, I have copyrights in this design. I don't need to register the design. So if you copied it, I can remove your listing within, 2 hours. So just have your own designer on freelancer.com or whatever, and design your own thing. So this is how you avoid copyright. Copyright is quite easy. Don't copy text from other parties' listing. Don't copy photos. Don't copy graphic designs, and you'll be okay. So copyrights, it's quite easy. Trademark is okay too. You need to do a search, but you'll be fine. Now with patents and design patents, that's more complicated because you go to your lawyer and you say, can you do a quick search to see if there's a patent on it? And then turns out it's quite expensive because the lawyer needs to do a thorough search to make sure there's nothing on that thing. And when I have a bottle, I can call it a bottle, and then you can call it a container for water. So the patent, when you search for it, you don't know which words you should search, and it's very, very difficult to find a patent for for a product without a brand name on it. So the only way to find, I think, for Amazon sellers to find the patent is either to search for a brand name, and I'll explain how, or to use a professional searcher. What I recommend doing is that if you copied, I'm using the word copied, but if you copied Nike's shoe, okay, and you want to sell Nike's shoe under your own brand, and you want to know, is that shoe registered as a patent, right? So what I would do, I know that you want to use Nike's shoe. So I would go on Google Patent or one of the websites, and I would look for all Nike's patents, and then you search on Nike's patents if that particular shoe is there. And that is easier than typing shoe on Google Patent where you have thousands of results. So many people do that, and I can tell you, if they remove you, if you're suspended, and you have an IP suspension, many of my clients then become terrific patent searcher because, the minute they're suspended, they feel like, look for it, and I found the patent. So, they can do it, not in all cases. It can be very difficult, but if you focus on a certain company and this is the original brand behind that design, then you should be able to find the patent. But if you don't know, and if it's like a generic product with dozens of Chinese different designs, then it will be very difficult to do it on your own.
And this is public information.
By the way, yeah. But by the way, I always start by regular Google. Okay. So, if you copy that particular shoe, I start with Google and I write Nike shoe model, blah, blah, blah. and very often you can find the answer on Google.
Yeah, I have the problem too. Part of the problem of dealing with suspensions is that the suspended seller has a lot of time on his hand.
Yeah. Yeah.
Right. Okay. So now, did you ever see a suspension purely on patent infringement?
Yeah. We see a lot of those. Many patent owners feel that Amazon doesn't really suspend the listing. So I don't know if you've noticed, but some are suspended and some only receive a notice, and the notice says go and speak with the patent owner and resolve this between you. So many patent owners, they feel like they paid a lot of money for the patent and Amazon doesn't do anything. Some of them, in some cases, Amazon does remove it. At eBay, by the way, they don't do anything. They say, we don't understand patents. It's, they're complicated. If you have a design patent, that covers only the ornamental features, that covers only the shape of the product, we can understand that because these are photos. For utility patents that, that cover the functionality, they don't understand it. And so Amazon, we see that in some cases they suspend the listing, in some cases they don't. When we get a case like that, the first thing we need to figure out is if the seller is indeed infringing the patent. So we look at the product and we look at the patent, we analyze the claims, and if there's no infringement, we do one of the two or both. We approach Amazon and we explain why there's no infringement. In many cases, they reinstate the listing, and if it doesn't help, then we approach the complainant and we explain that there's no patent infringement. In most cases, they'll retract the complaint if we are correct.
Right.
If you are infringing,
yeah, go ahead.
So if you are infringing the patent, you have basically two options. One is maybe to sell the product outside of the U.S. or outside of the country where the patent is registered. So we need to make sure there's no patent in other countries. And in many cases, you can reach an agreement with the patent owner, and some kind of license agreement where you pay a certain fee for each product that you sell, and then you can keep selling the product. So they license the patent. You pay for using the patent.
Right. Now, yeah, I did notice that some type of patents, they let you list and they keep the listing live, and of course, most they take off. But my question was, have you seen an account suspension just for patent infringement?
No, I've never seen an account suspension for patents only. I've seen account suspensions for trademarks only. I saw many times sellers suspended for infringing a trademark on the first month, and they got to Amazon, they just started, and then they infringed one trademark and boom, and they're out. So I've seen that, but I've never seen Amazon suspending for patent only.
Yeah, I've never either. So because I've been, if I can get one infringement, I'll probably want a patent because it seems like it's just between you and the seller, and they don't deal with it. Okay.
I think my favorites are trademarks, because sometimes the trademark appears on your listing, so you can always remove it from your listing and convince Amazon that now the listing is okay. So that that's the easiest part. With the patent, that's the product itself. So if you're infringing, you're in trouble.
Right. Let me ask you one question. I had this question for a while. When a brand owner files let's say a trademark complaint against a seller, so why don't they share that information? Meaning why doesn't Amazon share that information with the seller? Like, what's the secret?
I really don't know why. I gotta tell you. I mean, they're basing their entire work on the DMCA. The DMCA says that they need to notify the the seller that there was a complaint. And I don't know if you've noticed, but in the last 2-3 weeks or maybe a month, they started giving more details on those IP complaints. Did you notice?
Yeah,
So
I
now we
posted that.
see,
They put about the packaging or they put about the keyword, but that
right,
information is
the
so
keyword.
valuable.
Right, and now for patents, we see in most cases we see the patent number. The patent number appears there for design patents as well. Now we see for copyrights. Sometimes they do, sometimes they don't. It's like a big secret, and it's like a game for us. A client comes to us, and I'm suspended. I really don't know why. Usually the client says, my product is 100% okay because there are 40 other sellers selling it, so there shouldn't be any problem. And then, we try to investigate and we find that there's a patent on it. So yeah, it's like a game, trying to find out what happened there. I really don't know why they're keeping this as a secret. They could give you, without giving so many details, just the number, what it is, and who the complainant is.
Right, because if they would if they would explain to me where the complainer thought the trademark was, so then I can try to dispute it. But if I don't know, I'm just guessing.
Right. Yeah, so it's like a big guess and a game for us, but really it's not. It's really not funny. I'm not sure why Amazon does that, but I feel that they're trying to improve. So let's hope it all changes.
Right. Yeah. I just think they're always saying they're trying to improve.
Yeah. Right.
It's like always like right around the corner, the improvement. Okay, one last question. When I started these interviews, Apple filing infringements was a big discussion. I haven't seen them around lately. Any reason for that, or have you?
What large?
Apple.
Large
Apple.
app? No, not really. No, not really. I haven't seen Apple very active lately. I've seen other brands. I can't really talk about specific brands and specific stories. So that's the problem with lawyers. But no, I haven't seen Apple for a while.
Yeah, I just as you were talking, I was noticing that. Okay, Yael, Cabilly, I really appreciate the input. That was really great. Thank you very much.
Thank you. Thank you very much.
Okay, be well. Bye.
Bye. Bye. Bye.